So we're back with another offer to purchase and contract because it updated in July. So we need to go over the new contract so people know how to use it, what it says, what are the changes, all of those things. Are you ready, Chris?
I am ready. If this is your first go around, then one of the things that you'll find out is these forms, they change every year, July 1st. It doesn't mean there are going to be dramatic changes. And this year there were not dramatic changes, just a couple of things that needed to be said better, or moved in the contract.
I agree. So let's start with the first line because, we do love this whole thing. It's called an offer to purchase and contract. And Chris, tell us, why do they call this the offer to purchase and contract?
I'll do this very quickly, so if you need to listen to it again, just go back and rewind and listen to it again. But it's important that this form serves two purposes. When you make an offer on the property, it is just that, an offer to purchase. However, we know many times that it's either going to be rejected or countered. And if it is, in fact, there will be a protocol that you'll need to do for that. However, one of the options is that it could be accepted. So you'll have an offer to purchase. And if it's accepted and communicated back to the offering party, then it becomes a contract. You don't need a new form. I will caution you from the start. Please use your words offer and contract very specifically. They are in two entirely different things.
Yeah, what he said, and I'm just going to, kind of condense that. Basically, this one form is going to serve as an offer that a buyer usually gives to a seller. And in residential real estate, once the buyer has given the offer, the seller has signed the offer and told the buyer that they've signed the offer, then this same piece of paper now becomes the official contract. So while you're, taking your test, studying for pre-licensing or post-licensing, or even in the real world, just be really careful of, are you saying the word offer or are you saying the word contract?
Correct.
All right. So let's go, let's just go ahead and jump to section 1. Now, I know you all see there's some language there, and it's basically saying, hey, this is an offer to purchase and contract, and somebody's going to buy some real estate. And now we're going to break down what the contract says. So section 1 is our terms and definitions. And the section 1, it pretty much goes, a page and a half, almost 2 pages, right?
Yeah, it's introductory, but at the same time, it goes over a lot of what we refer to as defined terms. And we'll bring that up a couple of times today when we talk about what a defined term actually means.
Exactly. So section 1, the first thing we're going to do is start with the seller and the buyer. And we know that when we're putting in information here, we want to put a seller or buyer's first name, and then their, my handwriting, middle initial, and then their last name. And then what else should we make sure we do? That says last name. Whether or not they are married. Because we know if they're married, the attorney's going to want to know whether or not they're taking this as tenants by the entirety or joint tenants or tenants in common.
Yeah, on the first line there, of course, with the seller, people often ask, where's the best place to get this information? If you could get it from the deed, if you get a copy of the deed, which you should, it should identify who the owners of that property are, and all the owners will be all the sellers. And as Kandyce said, full legal names. Now, she mentioned middle initial on there, and I believe that is perfectly fine as well. I have some people who are paranoid and they will write out every single digit. If you want to do that, that is fine, but I think it's sufficient the way we described it here. But make sure you get everybody that's on that property. All of them are the sellers.
Yes, otherwise it just becomes a disaster. So whether it's for the seller or the buyer, first name, middle name or middle initial, the last name, are they married? And of course, if there's a junior or a senior or something like that as well.
And I told Kandyce I would not point out any big stuff here, but Kandyce, I'm going to do it anyway. One of the things we're having a disaster with right now are dealing with estates and trust and entities. If you end up running into any of that, and I don't think you will for test purposes, but if you run into it in the field, please contact your attorneys very, very soon and find out who the parties are that you need to have their signatures.
My favorite words, call your attorney or CYA. All right. So section C says property because, of course, we have a piece of real property, and we know from the chapter on deeds and transfer of property, and of course the chapter on contracts, we have to have a description that's going to work a little bit beyond just the street address.
Correct. And notice, and I didn't point it out in seller buyer, but notice you'll see it now here a third time under property. When you see something in quotations and capitalized, it means it's a defined term. So the property Kandyce mentioned just a moment ago, it goes like a page describing the what the property is. Well, later on in the contract, it won't actually do this whole description. It'll just mention the word property with a capital P. And what it means is all the things that we're getting ready to go over here.
Exactly, because it's going to be the land, and then it's going to, of course, which is going to have the improvements, and then the fixtures and the personal property, which we're going to break down in later paragraphs.
Yeah, if you let me throw in here just real quickly, and we don't need to make a big deal about this, but this is a difference from the old contract. They have actually moved the manufactured home portion of it to right under where it's property. This has always been in there. It was just in a different location in the past. And notice the question that it's asking. The property will or will not include a manufactured or mobile home. If you're dealing with any of the rural areas and you're selling a property that has a mobile home on it, we can identify it, because once we identify it, we can get down to the crux of whether it's personal property or whether it's real property.
Yeah. And they're still going to use the additional provisions addendum. This just lets everybody know, hey, there is a mobile home or manufactured home, whichever is going to happen.
Correct.
Right? Now we have here, the next section is where it asks for the street address, because that is very helpful. Right? We do want a street address, but really what we want to look at is going to be this legal description. So where would I find a legal description if I was a brand new agent?
I tell you, Wake County is a great place to practice because they do theirs so specifically. Wake County, I think I go to Wake County Real Estate Search or something like that. If you're dealing with some of the other counties and they don't have it quite as sophisticated on their tax records, just pick up the phone and call the county and ask them how to maneuver on this. But typically you can find this on the deed, on the tax card, and it's almost all online now.
Yeah, I mean, and you'll see these words that we talked about in class. Like we have a block, like the Latin block. It's going to ask you about the plat book if that needs to be. Here it talks about a PIN, a parcel identification number, or PID. And then sometimes it might just be a page in your deed book. So lots of different ways to do this. But I think at the end of the day, as long as people have searched not just what's on another MLS sheet, because we know we never use what's on another MLS sheet, but as long as they pulled tax records or gone to the GIS or Wake County or whatever county they may be in, I think they're good, because the attorney's going to look it up for them too.
True. And just one pro tip, you're going to find out that a lot of these have extended addresses or descriptions. What I would do is, because it's all online now, is cut and paste it into the document, and it keeps you from making a transcription error.
Yeah, I love it. Okay, our next section is purchase price, and I think that's pretty clear that this is going to be where the buyer, usually it's going to be the buyer, is giving this offer to the seller, and we're saying, here's what I want to offer you. And that's what that first line is going to be. Hey, how much do I want to give you, seller, for this property?
The most common thing that you're going to negotiate is, of course, the purchase price, and then the stuff that follows. Kandyce will get into some detail about, it shows you how the purchase price is going to be paid.
Because we know that basically overall, the buyer saying here, let's say we have a $350,000 house, and let's say it was on the market for $357,000, and we're going to offer, and I'll go ahead and write this in here, we're going to offer $350,000 even. All right. Now what we're going to do is break that down. How is that $350,000 going to show up for the seller? Now we are going to have a buyer write some checks. We've got the due diligence and the earnest money. So I'll start by explaining due diligence.
Okay.
Right? This due diligence fee is what a buyer is paying to the seller directly. That buyer is going to write a check directly to the seller. And look, it should be there by the effective date. So a seller should have this by the time they're signing and communicating over to a buyer. Right, but that's something more for post-licensing. right? So you're going to write this check to the seller buyer, and what you're buying is the right to walk away. You're basically buying a get out of jail for free card for a certain amount of time. So if you want to get out of jail, the jail being the contract, during X amount of time that we will talk about later, then you can, because you've paid this fee. It is allowing you to do all your searches, all your inspections, any negotiating on repairs during this time. And if something comes up, like you can't get financing or it doesn't appraise, then you can use your get out of the contract card.
Correct. Just a quick pro tip on this. Kandyce is exactly right. Notice the effective date. We will describe that in just a little while. Notice it's capital E, capital D, so it is a defined term. So it's going to be a very specific point in time. Also, please note that the buyer chooses how they are going to make this payment. Now, while it's negotiable, very few people pay cash today, but the seller may say, I don't want a personal check, I want a wire transfer. That's a possibility. So even that is part of the negotiation. But notice that there's a lot to that little sentence there on due diligence.
Mm-hmm. All right, so we got due diligence. Why don't you talk to us about initial earnest money? And then, I guess we should probably go ahead and talk about the additional earnest money as well. So start with the initial.
The initial earnest money, and of course, if you're taking a pre-license or post-license class, this is something that oftentimes students are easy to grasp because they understand if they've been involved in a transaction in the past. In most states, you have some type of earnest money. It's what I would call good faith money. It is money that you're putting up that shows that you have the ability to put together some money that for the seller in the event of a breach by the buyer. And in this particular case, it's asking how much is the buyer offering in this case. Notice that it says again how it's going to be paid. And there was one change, Kandyce, I don't know if you noticed this in the contract, but it used to give you options about when to deliver the earnest money. I won't go into what the old option is, but it says now that the initial earnest money should be delivered within 5 days of the effective date of the contract. So the reason I'm mentioning that to you is please make note of the difference between the due diligence fee and the initial earnest money. Due diligence fee on the effective date. Due diligence fee paid to the seller. Initial earnest money within 5 days of the effective date paid to the escrow agent.
Exactly. And those are small changes, but in small little details that can make a huge difference. And we'll get into later what happens if somebody doesn't give the money or check bounces. Not that we do checks all that much anymore, things like that. So if that's initial earnest money and it's due 5 days from the effective date, why do we have this additional earnest money? What?
The most common way I see that used today, like it sounds, additional earnest money typically comes later. The most common way I see that used today is oftentimes buyers are not putting up money during putting up earnest money during the due diligence period. They say, well, during the due diligence period, I could freely walk away if I wanted to. Not freely. The due diligence money would be lost at that point. But a lot of buyers and buyers agents are saying today is there's no reason for me to give you any additional earnest money until the due diligence period has expired. The reason I mention that to me, Kandyce, the additional earnest money is more about strategy.
I think so. I agree. And it's something that, you'll work with your BIC or your broker in charge to talk about the strategizing and the negotiating and things like that. However, if you are going to be dealing with any kind of additional earnest money, remember that it's a time being of the essence date. And of course, maybe I shouldn't cross it out. Maybe I should highlight that instead, time being of the essence. And notice it either has to be cash, official bank check, wire transfer, or electronic transfer. And what does time being of the essence mean again?
Two things about that little short sentence right there. Time being of the essence mean something must happen by or before that date. Otherwise, and you can see where she's highlighting right now, you would fill a date specific in there. It must happen on or before that date, or you lose your right according to the contract. The other little thing that you may not have picked up if you haven't seen enough of these is notice that the additional earnest money cannot be in check. And the reason for that is often these come up late, close to closing. And so if the check bounces, there would not be a remedy. So it's not even an option.
Exactly. Now, just to remind everybody, I mean, I'm assuming that they know this already, but if somebody backs out, so I'm a buyer, I write a check for due diligence to you because you're the seller. If I decide to use that get out of contract card, then I haven't broken any rules. So you get to keep my due diligence money because I used the card. I got what I paid for. But if I did already give you earnest money, you're agreeing that that's going to come back to me, and we'll see it later. But I think it's good to point out, I mean, you can never hear that too many times.
No, and you can never ask this question too much, because if you're listening to this while you're taking a pre-license class, you will absolutely be tested on this, probably multiple questions on this. During the due diligence period, the earnest money is not at risk. You're not going to get your due diligence money back, but the earnest money is not at risk. If you passed the due diligence period and you're still in the contract and then you back away, only then would the earnest money be at risk.
If you back out after that due diligence date, that time being of the essence date, you would lose your due diligence money and your earnest money, and pretty much it. But if you buy the house, you get them both back.
Thank you. Yes, you will get credited those at closing.
All right. So we got all of those, and I think we can just, an assumption. Well, let's say this. Let's put in some fake numbers here. Let's say we gave maybe $5,000 in due diligence.
Okay. Yeah.
All right, so I'm going to put in $5,000 in due diligence. And how much do you want to give on initial earnest money?
I like to put somewhere between 1% and 3%. So let's say another, I don't know, let's make it easy, round numbers, $10,000.
All right, we'll do $10,000. Any additional earnest money that you'd like to put down?
It's atypical. Like I said, It may be a timing thing where the $10,000 would be at a later point than the initial. But having said that, it's rare that I see both, except in rare circumstances.
All right, and I'm just going to NA the rest of these because we're not going to really get into those. But what I want to point out is that this whole section is almost like a big math problem. We're saying, hey, seller, I'm going to give you $350,000 at settlement date, but I've already written a check for the $5,000 for due diligence and the $10,000 for earnest money. So really, the balance of what I need to come up with would be, you're the math genius, what is that?
Well, it's going to be $335,000. More importantly, it's the first line, $350,000 minus every other line that you have filled in. So minus $5,000 minus $10,000.
Because these two together are $15,000. So we're doing the $350,000 minus $15,000, which is the $335,000.
Most of your software programs will do this for you. However, some of the agents try to get creative right there, and they think it says something other than what it does. They say, well, should this be the loan amount? Should this be how much I'm bringing in cash? No, it's the first line minus any credits that you have. That's what you're responsible for bringing to closing.
Now, I do want to point out, even though we didn't go over it, if somebody is going to be assuming a loan or doing seller financing, or there's some type of builder deposit, that is a true CYA. Call your attorney and your BIC to make sure you don't mess this up.
We have forms for this. Haven't been a BIC for years. I don't know that I've ever seen them more than just a few times. Maybe the builder one more than anyone else. But having said that, these are extraordinarily rare. But what Candace said is correct. If you need one, it's time to talk to your BIC. And your BIC may end up having to talk to someone because they're so rare.
Exactly. Now, before we go to page 2, Chris, I'm going to go ahead and I'm actually even going to change colors here. Tell me about this form jointly approved by the North Carolina Bar Association Real Property Section and the North Carolina Association of Realtors, because we know in pre-licensing, that's a big deal.
Yeah, if you're taking this class as a class, then this is something you'll have to know. These forms are created, and when we say our joint forms, it means that they're created by these two entities together. What that also means is only someone who is a member of those entities can actually use these forms. One of the things that happens sometime in real estate is you'll have someone come to you and say, hey, I'm thinking about selling my house. And you're like, well, that's great. I'll be glad to list it for you. And they'll say, well, I don't really need any help, but could you provide me the forms? Actually, the answer is no. You cannot unless they are a realtor or an attorney, a member of the bar, because these are actually trademarked for these organizations.
Yep, because the commission is not the one that writes these forms. I think that is huge. And I know given the last 2 years, a lot of agents have come and said, Why hasn't the commission done something about due diligence? Well, the commission didn't set up due diligence. The Realtor Association and the Bar Association did. So these are definitely forms not written by the commission, but the commission tells us, hey, if we're using a pre-printed form, it has to meet these criteria. And then the Bar Association and the North Carolina Association of Realtors wrote this so that it's a benefit for being a realtor.
Excellent point. Let me make one more point before we leave this. Down in the bottom right-hand corner, you see the name of the form, Standard Form 2T. The test will never test you on the numbers of these forms. However, what the test will test you on is knowing when to use the appropriate forms. The standard offer to purchase and contract can be used for selling single-family homes. It can be used for selling condos, townhouses, and things like that. But it would not be used for land. The reason is we have a better form for land. The point they're trying to make here is that if you're using these forms, make sure you use it for the correct transaction. And notice that Kandyce jotted in, not commercial, not land, not this form. Not saying we don't have forms for that. It's just not this form. And then also notice the date down in the bottom. This form went into existence on July 1st of 2022. You can start using this form. Listen, if you use an old version of the form, technically, the contract will be binding between the parties. However, agents could be considered negligent for using an old version of these forms.
Exactly. Wow, that's a lot for the first page, but there's a lot of really good information in this first section. And a lot of it will show up on your pre and your post exam. So I'm going to scroll over to page 2. And we're going to see in this contract a lot of these like blue boxes. If it's got color or it's a box like that with a note, that is telling you, the agent, you, the student, or the buyer or seller that they need to pay attention. Pay attention, right? Now that one is just talking about, hey, it's okay if we do electronic transfer. Everybody's good with that. That's fine. But this next paragraph is full of stuff, Chris. I kind of love this paragraph.
I tell you what, it's probably the one I talk about more than any paragraph in the contract.
Okay, so I'm going to read it. Well, I guess we'll do sentence by sentence, maybe?
Yeah, the first couple of sentences are going to be vitally important.
All right. So should the buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or if a check or any other funds paid by buyer be dishonored, they bounce, right? For any reason by the institution upon which the payment is drawn, the buyer shall have 1 banking day after written notice to deliver cash, official bank check, wire transfer, or electronic transfer to the payee.
Okay, so let's start with that. And I said that this is probably the one that I have the most questions about from my agents. Notice that I mentioned a couple of dates to you earlier. And when we talk about these dates, in some cases, these dates are vitally important. So, for example, when we say if you fail to deliver the due diligence fee in a timely manner, well, technically it should be delivered on the capital E, capital D effective date of the contract, okay? If it's not, at that point, it's late. So you could look at it on one hand and you could say that the buyer is in breach of this contract. But what this paragraph right here does is it gives a remedy. Yes, he's late, but how do we fix it? And then notice it says, if he's late, if he wrote a bad check, these are not good things, but here's how we fix it. The listing agent makes a written request for the money, and then notice that they have to give the buyer 1 banking day. This is the only place in this contract that the word banking day is actually mentioned. Every other date in this contract is just a calendar day. The reason I get questions about this from my agents is if an offer goes under contract and they don't have the due diligence money, oftentimes they'll say, well, daggone it, we don't want to sell to that buyer. Can we sell it to somebody else? If you follow this specific standard that they put in the contract, only if the buyer is not able to redeem themselves would you be able to sell it to someone else.
So basically what you're saying is just because, seller, you didn't get your due diligence or your earnest money on time, it doesn't mean that the contract is void or that the seller can back out or that it's voidable. It means the seller needs to ask in writing for their money and the buyer's got 1 banking day to make it right.
Would it shock you that a lot of houses go under contract on Friday and Saturday?
No, it would not.
Would it shock you to know that a lot of buyers are out of town?
No, it would not.
So it's also difficult to get the due diligence money in time. Sellers get upset. When's the next banking day if you go under contract on Friday?
Monday.
At 5 o'clock, Monday at 5 o'clock. That means that seller has been off the market all weekend, but he doesn't yet have the due diligence money. But that's what the contract says.
It's really, on the test, probably not that much detail, but once they're, no, that's okay. These are things that people need to know, right? So let's go on with our paragraph. In the event buyer does not timely deliver the required funds, seller shall have the right to terminate this contract upon written notice to the buyer, and seller shall be entitled to recover the due diligence fee together with all earnest money deposit paid or to be paid in the future. In addition, seller may be entitled to recover reasonable attorney fees and court costs. Right? And then it says, see paragraph 23 for a party's right to attorney's fees incurred in collecting the earnest money deposit or due diligence fee. So, there's a lot there, but basically it's saying, hey, guess what, buyer? If you don't pay, if you don't make this right, the seller has the right to, and it helps if I don't cross out again. The seller has the right to terminate this contract upon written notice.
Yeah, and again, I could go off on a dissertation on this, but that's exactly right. If the buyer doesn't do what they have to do to redeem themselves, this is one of the few places in the contract that the seller can terminate the contract.
That is very true. All right, shall we do the next section?
Absolutely, keep moving forward.
So we've got earnest money deposit, which we talked about a little bit. Now, I do like to point out to people that the first line, the initial earnest money deposit and the additional earnest money deposit and any other monies paid or required to be paid in connection with this transaction are now just going to be kind of lumped into one earnest money deposit, which a lot of times when we're talking to people and things like that, we'll call it the EMD. And so when you see EMD, we're talking about earnest money deposits. We're just kind of lumping them all together.
Yeah, this paragraph right here is actually fairly simple, and without being an attorney, you could probably figure this out, because what it says is if the offer is not accepted, buyer gets his earnest money back. If a condition of the contract is not satisfied, then the earnest money shall be returned to the buyer. In other words, if for some reason they can't go under contract, then the buyer just gets his earnest money back.
And then it does also point out that at closing, the buyer will get this money back, right? So let's talk about escrow agent. You go for it, Chris.
Okay, on the escrow agent, you are typically the buyer's agent is writing this contract, and typically you will know who your attorney is going to be, or whether the firm that's listed the property holds earnest money. Whoever is going to hold this earnest money will be identified right here, and your buyer will write the check to the trust account of whoever the escrow agent is. Could be an attorney, it could be a listing firm.
Mm-hmm. So the big note, we got a note here, right? So if we know that there's a note, this is something that we need to pay attention to. So let's talk about it. In the event of a dispute between seller and buyer over the disposition of the earnest money, which is basically a fancy way of saying they disagree, that's held in escrow, because we know our earnest money, our escrow monies, whatever you want to call them, are held in a trust account or an escrow account, right? A licensed real estate broker is required by state law, and the escrow agent, if they're not a broker, hereby agrees to retain the earnest money deposit in the escrow agent's trust or escrow account until that escrow agent has obtained a written release from the parties consenting to its disposition, or until disbursement is ordered by a court of competent jurisdiction.
Yeah, just real quickly on that, this used to always be a test question. With due diligence now, this rarely happens, because there should not be disputes about earnest money given the due diligence period. So having said that, you don't get tested on as much, but here's the deal. If the two parties can't agree what's going to happen to the earnest money, firm or or attorney, keep that money into your account to get a written agreement of the parties. And notice that it says specifically written. If they pick up the phone and call and say, hey, just split it 2 ways, don't do it. Get it in writing. If a court of competent jurisdiction tells you what to do with it, that means there's been a lawsuit over the money and you'll do whatever the court says.
Or they have the right to just, I'm going to say just, but there's a whole bunch of procedures, and they can give the monies with the clerk of court, and then they can let the judge handle it.
That's right. Let the parties fight it out with the clerk of court.
Right. And then this section right here, we do like this section. I'm just going to go this right here. Oh, look, that's nifty. I didn't know that did that. That right there says that we have to tell people if we're going to be keeping the interest, which most people are, on their earnest money. Right. So that's just the acknowledgement. Notice it's separate and it's capitalized. So that's a great test question.
Yeah, from a test question standpoint, it would look something like this. Can a real estate firm put their earnest money into a trust account? And the answer is yes, as long as they have a written agreement of the parties, and this is where they get that agreement.
Yep, and that earnest money is going to that firm. All right, another big one, the effective date. Go for it, Chris.
Okay, this is actually a hard paragraph to read, but it's an easy paragraph to understand. We have mentioned a couple of times defined terms, and you can see capital E, capital D, effective date. I keep saying it that way. It's in quotations. Every time you see the word effective date in this contract capitalized from now on, it means just this. Let me simplify for you what this paragraph says. Before an offer becomes a contract, things have to happen. There, first of all, has to be a bona fide offer, and it has to be accepted, but then it has to be communicated back to the offering party. Now, in the field, this is difficult because when we talk about a bona fide offer, we're talking probably a written offer. Now, listen, there is such a thing as oral offers, but they're not binding because we all know, because of the statute of frauds, contracts have to be in writing, signed by the parties charged therewith before they're binding. So oftentimes what agents do is they say, well, we'll give you $350, and the other side say, well, we'll take $350. Yay, we're under contract. No, you're not. You're not under contract until there is a written offer, a written acceptance by all parties involved, but yet there's one more thing that has to happen. It has to be communicated back to the offering party. Only at that point is it a contract, and we have now reached the effective date of the contract. This is not some vague point in time, Candace. That's the point I'm trying to make.
I like to say we have to close the circle. If the buyer did the first initials in signing, then the seller is going to accept it, and they are going to initial and sign if need be. And then that seller, or anybody on the seller side of the transaction, has to tell somebody on the buyer side of the transaction that we're actually under contract. And there's going to be lots of questions dealing with agency as well as contract acceptance on the test. So make sure that you understand this section. If you're watching this, I don't care if you're in pre-licensing, post-licensing, or you're, out there in the streets actually buying and sell, helping people buy and sell real estate. This is so important because people get their feelings hurt all the time. They call one of us almost in tears. But what? But they told me. But they said. At the end of the day, did everybody sign and did everybody know? Everything else is fluff.
Yeah, if you're taking a pre-license class, you should insist that your instructor make you understand this. Mm-hmm.
Okay, next one we got due diligence, which we've kind of talked about. So let's hit this due diligence and this due diligence fee together. And what I want to point out first is that it's a negotiated amount. So every time one of you all ask me, well, how much should it be? It's whatever you negotiate, if any. If any. I'm going to go ahead and circle that. If any. Do you have to have due diligence or earnest money for that matter?
No, they are not required for a contract to be valid. Now, keep in mind when you go back and study your contracts, remember, consideration has to be there, but you should understand by virtue of that due diligence fee and earnest money are not consideration for the contract.
Mm-hmm. So you're paying due diligence from the buyer to the seller for the buyer's right to terminate the contract for any reason or no reason during the due diligence period. You can use your get out of jail / get out of contract card for any reason. You could just wake up and be like, my left pinky toe hurts. Fine. Get out of the contract. That's why you're paying the seller for that right.
Perfect. Yeah. And these three paragraphs go together here. What is due diligence? It's the buyer's opportunity to investigate. How did he get that? He paid a fee. What did that fee buy him? The right to walk away. So there's a flow that goes to these three paragraphs.
Exactly. And we know it's going to be going directly to the seller upon the effective date, and it's going to be given back to the buyer at closing. Remember, if the buyer buys the house, they get back the earnest money and the due diligence money. But if a buyer walks away during due diligence, they will lose their due diligence money. They will get back their earnest money. But if that buyer walks away for any reason after that due diligence date, which we said was time being of the essence, that buyer will lose their due diligence money, their earnest money.
Yeah, correct. Just a couple of things, and again, I'll go quickly here because they're not going to be intestable. But the due diligence fee, you are going to lose it. It's not going to be refundable, except in very, very rare circumstances.
Like if the seller breaches.
Very rare circumstances that we're not qualified to say because we're not attorneys. And then if he goes past the due diligence period and he loses the earnest money, the buyer loses the earnest money as liquidated damages, meaning, seller, this is all you're getting. The due diligence fee because you deserve it. And if it passes the due diligence date, the earnest money. But liquidated damages means don't come back and sue me for more. That's all you're going to get.
And so we got, that's perfect. We think we've explained it. The due diligence period, the due diligence fee, the due diligence, it all goes together. And we know it is time being of the essence. This is a date that you must hit.
Perfect.
All right. So let's go on to page 3. And our very first word up here is we've got settlement, but then we have settlement date, and then we have closing. So what's the difference there?
If I can be brief on these, the way I look at it is these paragraphs flow together. Settlement is a procedure. It's when the attorney is collecting the paperwork necessary to close a transaction. The settlement date is the date that they are targeting to finish this transaction. But despite the fact that they've added a lot of words to the closing paragraph, I still think of the closing paragraph as this. A transaction has not closed until the deed has been recorded in the buyer's name. So to me, recording constitutes closing, or vice versa on that. Settlement's a process, settlement date's a target. Closing is when your deed is recorded. What would you like to add?
I just like to always point out that before an attorney does the recordation of the deed, they do an update to the title search, everybody is cleared, and then they record. So if you have a closing on a Friday afternoon and it's late on a Friday afternoon and the attorney does not get a chance to record that deed before the Register of Deeds closes, that house does not belong to the buyer until it actually records on Monday, which means don't give them the keys. Do not be fooled. They're trying to get you. They cannot get, and by they, I mean the buyer, should not be having keys until it records. Just like you aren't getting a paycheck until it records.
Perfect.
Right? And then we have a big red warning box, which basically says, even though there is no law that says we can't conduct a closing, why would you want to?
Yeah, it's very rare in North Carolina that it would be anything other than an attorney handling the closing. A lot of other states may do it slightly different, but don't fall for it. In North Carolina, let your attorneys do the closings.
I don't want that.
Even if you tried to do one yourself, which you shouldn't, there are some things that are legal documents that would have to be described, and that has to be done by an attorney.
Exactly. Okay, our next section is a special assessment section. So a special assessment, what is that, Chris?
Well, a special assessment is going to be, I like to refer to it as it walks like a tax and it talks like a tax. It is a tax, but it's a tax for a specific thing. So, for example, your taxes just come year in, year out, but a special assessment might be when the city brought you water and sewer and they charge you for bringing the lines. It's a one-time tax for a specific improvement. And it can actually be done on a private case basis as well by a homeowners association. For example, replacing the roofs of a condo, and then they have a special assessment rather than pay for it out of the condo fees. But think of it as being a one-time tax, so to speak.
If your property got the improvement, so if your property got the lights or the street lights or the sewer hookup or whatever it is, then that property pays the assessment.
Correct.
And we do see that we'll talk about who's going to pay the special assessments a little bit later on. Correct. Whew, that was a big section 1, so let's move on to section 2, which is about fixtures and exclusions. Now, on a scale of 1 to 10, Chris, how important are fixtures?
It's about a 12. Okay, I mean, this clearly is probably going to be the first thing that agents are going to screw up on in their careers. Are fixtures, and it's because of the haste and pace of the business. I would highly encourage you, regardless of what we say here, this is where you want to spend some time reading this paragraph very, very closely, because we're talking about items that if it's a fixture, and you know this from class, a fixture was once personal property, but now it's attached to the property, then it's going to convey with the property. You can get some people really upset, and sometimes there could be significant value. I was dealing with a transaction on Thursday with a very sophisticated agent, and believe it or not, fixtures was one of the issues that came down to be controversial.
Fixtures, fixtures, fixtures. So there's another warning in a red box, and this is to the buyer and seller. The party should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not a part of this contract. Buyer and seller should be specific when negotiating what items will be included or excluded from the sale. I mean, it says it right there. You should not assume, because you know what they say when you assume. I'm not going to say it right now, but it's a bad idea. If you want something to stay, if you want something to go, you need to make sure it is addressed in this offer to purchase and contract. It doesn't matter what the MLS says. It doesn't matter what you talked about. It needs to be in writing here. That is the best way to tell whether or not something's a fixture or if it's staying, it's going, what this contract says.
Perfect.
All right. So it does in section A, it says that fixtures are included in the purchase price, and those are going to be free of any liens or anything like that, right?
That's right. You don't owe the bank, or you're going to take care of that at closing.
Mm-hmm. And then we've got some items that may not be considered fixtures per se, but we're going to agree that these specific items are going to come with this purchase price, right? And that's going to be a traditional and smart versions.
Yeah, just real quickly on this, please understand that this list is not comprehensive. If you didn't pick up what Kandyce said in the previous paragraph here, notice that the previous paragraph said all fixtures are included in the sale. Then it came back and gave specified items, which over the years have occasionally been controversial. So the argument that I had on Thursday, it had to do with this list, and they said it's not in this list, therefore it's not a fixture. And I had to take them back to the previous paragraph and address that.
So do you want to point out maybe some of our favorites on this list?
Well,
like I think doorbells and chimes.
Interesting. My favorite on the list is garage door openers. And the reason garage door openers is down right there. Right here.
Oh, there we go. Oh, look what he did. Okay. Look what he did, y'all.
While she's fixing that, I'll say why garage door openers are my favorite is because oftentimes I'll have someone in class where they've read or they've listened to something online and they'll say, tell me what a fixture is. And somebody will say, if you took the house and shook it upside down,
I say that.
Anything that fell out would not be a fixture. Well, the garage door openers are not literally attached to anything.
But they are a specified item.
They are defined by the contract as being a fixture. That's why I like that specific one.
Well, that's a good one. Well, we got all stoves and ranges and ovens. Remember, that can be a big one. And these, including existing bulbs. If you're fancy-dancy like me, you can't have my Philips smart bulbs. Those things are like $50 or $60 a piece. And I got like 8 of them. No.
Can I show you an interesting change that they made this year?
Yeah.
Notice over here where it says swimming pools. Can you put your pen on that?
Yes.
And through the whole sentence there. Mm-hmm. Here's how things get controversial. Notice what they say here. They say swimming pools, spas, and hot tubs are fixtures. Well, nobody's going to argue that. But notice that they came back this year and said excluding inflatable pools, spas, and hot tubs. Do you know what that means, Kandyce?
Means inflatable don't stay.
That's right. That means someone got into an argument about an inflatable hot tub, so the attorneys came back and changed the language.
Makes me think that I might need to get an inflatable hot tub. Let's just because it's good to know, any mirrors that are attached to walls, ceilings, cabinets, or doors, and all bathroom mirrors. That's something people fight about a lot.
Let me show you one more change down here in the window, door blinds, and shades. This has always been the case. Window, door, blinds, and shades have always, in fact, been fixtures. However, notice that they now put curtain/drapery rods in brackets, because last year what it said was curtains and drapery rods, and some people read that to think that the curtains were a fixture, but what it always meant was the curtain rod was a fixture. So you see things, and the reason I point those out to you, one, is because it's a change, but also secondly, don't overthink this. If there's a question or a concern, Kandyce is going to show you in just a moment where you can write it in so that there's clarity on fixtures.
And then the last thing, because you're absolutely right, is the, landscape and outdoor trees and plants, except in movable containers. If it's in the ground, it stays. If it's in a movable container, it can go. Right. Anything else we want to point out there? I think
that's a lot. Yeah, that's a lot.
It is. And this is a really good list. Now, I absolutely love having a smart home, but please make sure that people unpair and delete data from devices. If I were to sell my house, I don't really want to see who's coming in on the ring now. So just a little bit, just something you want to talk about with your clients.
Yeah. Just address that. That is a specific to some houses, but you're seeing more and more of them.
Mm-hmm. Our next section talks about items leased or not owned. So maybe you're leasing a satellite dish for your cable or something like that. Or what else will we lease?
Well, they actually give a good list now. Antennas, satellite dishes, receivers, alarms. I see a lot of alarms that are this way. And here's the idea. If the seller doesn't own it, he can't sell it. So if your client thought they were getting a security system and it was not owned by the seller, then the seller can't deliver it. Now, to me, this sounds like a material fact that should be discussed between the agents and the parties.
I agree. And then sometimes you have sellers that have something like, there's always that classic of somebody's aunt's, chandelier. It's a family heirloom. If there's a fixture or an item from the previous list that the seller does not want to leave, they need to make sure it gets included in this section. Other items that do not convey.
Yep, and a little pro tip on that. Notice what Kandyce said is correct. Seller, if you're going to take it with you, and we'll put it right here. Having said that, look at the line at the very bottom of that.
Seller shall repair any damage caused by removal of any items excluded above.
That's right.
Fix my walls.
That's exactly right.
All right, that page went a little bit faster.
But they do need to study that on their own. It's extraordinarily important to study that on their own.
Yes. So section 3 is personal property, which kind of relates to fixtures because a fixture is going to go with the real property. Personal property, obviously the seller could take with them. But there are times when a seller might want to leave or the buyer wants the seller to leave personal property. And what kind of things do we usually see there?
Well, let's just go ahead and cut to the chase on this. We're talking the refrigerator. That is by far the most common personal
Washer,
property.
dryer, too.
Washer, dryers are getting to be common. I'll tell you why I didn't throw those in just a second. But the refrigerator, because it's personal property, if the buyer does want it, and keep in mind, the buyer's agent is typically writing the first offer, okay? They should write in here, and my advice would be to be as specific as possible.
Yes.
Maybe even with a unit number or something to that effect. But if you want personal property, you literally have to ask for it in this contract. Now, test question alert, you will absolutely be tested on this. Just because the MLS says you're getting the refrigerator does not mean you're getting the refrigerator unless it ends up in this offer to purchase. One last piece, and then I'll let you talk about it. The only reason I did not mention the washer and dryer is in the field, lenders are starting to get real concerned about personal property. And if you try to put too much there, it's not a contractual issue. It's actually a finance issue. Sometimes underwriters will kick it out.
I know. It's like they know what's going through your brain because they added this line. Buyer is advised to consult with buyer's lender to assure that the personal property items listed above can be included in this contract.
Boom. Exactly.
All right. Hey, look, section 4, buyer's due diligence process. All right. Now, this is a big thing. And in case you didn't know, how we do due diligence here in North Carolina is Different is special. I actually happen to love it, but some people don't. I mean, if you don't love due diligence, then have an attorney draft your own contract. But until then, we have due diligence, and people need to understand how it works, right? And now we've got a warning, and there's bold in this warning, right? Because it says buyer is strongly encouraged to conduct due diligence during the due diligence period. Right?
Yeah, the logic behind that is if your buyer is going to walk away, wouldn't it be great to know what the problems are with the house during the due diligence period? If the house doesn't appraise and I want to walk away, I should do that during the due diligence period so my earnest money is not at risk. If the home inspection comes back badly and I want to walk away, I should do that during the due diligence so that I don't risk my earnest money.
Exactly. Or sometimes it takes a while to get an appraisal because you got to make sure you can get your loan, or you want to try during that period, or whatever. Maybe the inspector got sick, he had to cancel. He or she, I should probably say. The seller is not obligated to grant an extension. That due diligence date is time being of the essence. They could grant you an extension. They could also charge you for that. Or they could say, nope, no extensions for you. Right? So that's a very, very important point. Anything that the buyer wants to know about the house needs to be done while they're, in that due diligence period. Now, after the due diligence period, they can do investigations, but if they find something and then they decide to back out, they're going to lose that due diligence and earnest money.
Yeah, I think that you lose your leverage outside of the due diligence period. The buyer loses his leverage outside of the due diligence period.
Now, that doesn't count for things that the seller had to do, like make sure they're giving you good title or anything like that. So, if the seller doesn't do what they're supposed to do, any of their obligations, they can't give you a general warranty deed. This is going to be called an attorney. But basically, overall, your buyer needs to make sure they get all of these questions answered, because there is no loan or appraisal contingency in our offer to purchase and contract. Right?
Yeah, and this is the point in the contract where I take a little bit of a break. So I'm going to turn this over to you, and here's why. Provision 4, the buyer's due diligence process. I hope all of you end up going to places where you have a strong broker in charge that you can talk to, and you have strong mentors you can talk to. There is nothing in Provision 4 that is agreed upon. There are no
agreements.
There are no blanks in there that need to be filled in. However, if you're trying to create a checklist of things that your buyer should be doing, this is an amazing place to start your checklist. And with that, I'll sit back and be quiet.
Okay, well, there is a list, like he said. This contract is saying, hey, buyer, you want to make sure that you can get your loan. Because if you find out you can't get that loan after due diligence, you will lose that due diligence and earnest money. Right? You should do your property investigations. So that buyer should check out, okay, what's the condition of the house? Remember, in North Carolina, all real property is sold as is. We are a true caveat emptor state. And the seller does not have to tell you anything about buying that house. It's kind of like buying a car on Craigslist, a used car. You wouldn't expect the seller to tell you, oh yeah, and then this happened and that happened. You buy a used car on Craigslist, you go get it checked out. You buy a house in North Carolina, you go get it checked out. So you want to do, find any inspections. Is there radon? Is there something wrong with the house? Are there any termites? All of that is here. You want to do that during this period. You want to make sure that you review your documents, your HOA, your documents for restrictive covenants and bylaws, anything that has to do paperwork-wise with the property, look into it. Make sure you can get insurance. Make sure it appraises. Make sure, most definitely, that you get a survey to make sure that the boundaries of your lot, of whatever you're trying to buy, they're in agreement, and of course that there are no encroachments, because encroachments are another CYA moment. Call your attorney. Check the zoning. Check to see if you are in a flood hazard. And just a reminder, both the buyer and the seller's agent should be pulling up FEMA flood maps. Right? You want to make sure that you have utilities. You definitely, because we know it's a material fact, want to make sure that we're looking to see, are the streets publicly or privately maintained. Right? And of course, look into any special assessments. And I think that's pretty much it. Yeah.
Yeah, there is one thing that I'll throw in as you're wrapping that up, and I thought it was in there, and I'm sure I just missed it as it was coming through. In the field, you will have a form called a professional services disclosure. And what that disclosure does is it shows that you advised your client to do the necessary research on the product. And having said that, sometimes, even though it's good advice, buyers will not take your advice. So what this form does is shows that they either accepted your advice or they waived their right. Now, if you've already put 2 and 2 together, understand, of course, that I want to help my client as much as possible, but I also want to limit my liability. Oftentimes, if they see it listed in the contract, they'll say, oh, well, the attorneys thought that was important to do as well. So maybe I will, in fact, get that investigation.
It's all about limiting your liability. Right? So we're going to still be in this due diligence section, right? And it's a good thing to remind your buyers that this contract is not contingent or conditioned upon them selling another property. There's a different form for that.
There's not.
It used to be a different form.
We don't have a standard form, which brings up another teaching moment because we don't have a standard form.
Not anymore.
What they're literally telling you is if you want to make this contract contingent upon selling your other home, you need to go to an attorney and have one drafted for your buyer's needs.
All right. And then, we've got our repair negotiations agreement. Remember, houses are sold as is. A used house is like a used car in North Carolina. The property is being sold in its current condition.
Yeah, did you notice the change in format? This is another one of the changes for this year. And keep going to that bottom line right there where it says seller may but is not required to engage in negotiations. And some of the agents really like that change because so many people come back to them and say, well, it's a safety issue or if it's a code issue. They are still not required. They might engage in negotiations, but they are not required to.
Used car.
Yep, exactly.
Used car. All right. Now, buyer, while you're doing your inspection, if you or your inspector or somebody else working with you damages the property, they need to fix it. Right?
Please use insured resources.
Right. And if you fall off the roof or something like that during this inspection, you are not going to be able to sue the seller, not unless it was unusually dangerous. But I'll let an attorney handle that one. And then this section, the buyer's right to terminate, is literally the language that says that this buyer has the right to terminate this contract for any reason or no reason, as long as they deliver to the seller written notice of termination. Right? And remember that is time being of the essence. And if that happens, the contract is terminated and the earnest money shall be refunded to buyer.
Okay, we've said that a couple of times, but just to be slightly more specific on that, during the due diligence period, the buyer has a unilateral right to terminate, meaning that the buyer can terminate, but the seller can't during that period of time.
And then, of course, our last line here, the closing shall constitute acceptance of the property in its then existing condition unless provision is otherwise made in writing.
Perfect.
Whew. Now, I do believe, we're a couple pages in, but I think the heaviest stuff that we have to know for this test are in those first couple pages. Would you agree, Chris?
I think that's probably right. Descriptions of the party and fixtures, huge. Understanding due diligence, huge.
So we're going to go through the other sections. We'll point out some big things, but I don't think it's going to be quite as detailed as what we did before. So our next section is buyer representations. And Chris, talk to us about this.
Well, I want to say this about the word, and it goes to understanding contracts. Notice that these are buyer representations, not obligations. So as the buyer is putting information in here, they should do that in good faith. They should answer these questions in good faith. But if they don't turn out to be 100% correct, it's not going to be a violation of the contract. Let me give you the most common example here. We're asking them how the buyer is going to pay for the property. And some buyers plan to pay in cash. Well, the question you ask is, are they qualified to pay in cash? And if they have the money and can pay in cash, that's fine. They can check that box. But given the fact that we have low interest rates today, they may switch during the contract period and go to a conventional loan. If that's the case, it's absolutely fine. I get questions from my agents all the time. He told me he was going to pay cash, but then he switched over to a conventional loan. And they want to know whether the buyer's in breach. The buyer's not in breach because the buyer made a good faith representation they were going to pay cash. They just changed their mind.
Yeah. So what if I was a seller, I would want to know if I'm accepting an offer, hey, are you paying cash? And if you're not, tell me what type of loan you're getting, right? Are you getting a first mortgage and a second mortgage? Are you getting a conventional loan, or maybe it's FHA or VA? Maybe it's USDA. Maybe you've got some other monies coming up. I mean, you just really want to make sure that that seller knows how you're paying, how they're paying.
Right. And to go back to what I was saying just a moment ago, it doesn't matter which one of these things are. You as a listing agent should verify that they have the ability to do it, whether it's cash or finance, and make sure that they are pre-qualified, pre-approved to be able to do that.
Now, it is considered a material fact, material change. And if your buyer is changing what they're doing, it must be disclosed, but they're not in breach. Right? Now, if you think they just flat out lied, that's another CYA moment. Call your attorney. Right? Now, this is representations. Correct. And so the buyer needs to tell the seller, hey, do I need to sell or lease another property in order for this whole transaction to go through? And if so, you give more information like, hey, am I already under contract? Or am I going to be listing it? Or it has been listed? Or, maybe they're doing it as a for sale by owner. We're just representing information to the seller so they know.
And remember, that does not make the contract contingent upon that sale. It's just material information that the seller deserves to know.
Exactly. Let's see. I think I want to jump over to the Residential Property Owners Association disclosure statement, which we lovingly call the RPODs. Get it? Residential Property and Owners Association disclosure statement.
That gets to be a lot if you have to say it multiple times.
The RPODs. So, Chris, do you want to go about it, or should I?
Well, from a simple standpoint, I'll go over it simply. You add what you think you need to add here. This is simply asking you a question. Buyer, did you receive a copy of the RPOD before making an offer? If you remember back to your classes, the RPOD is required before the buyer has made an offer. If the buyer receives it before they make an offer, it wipes away any opportunity that they have to walk away because of their lack of receiving this particular form. So you just check box 1. I would hope almost 100% of the time that you could check box 1 if it's a resale. Box 2 says you did not receive the form that you were entitled to, and then it actually describes the 3-day right of rescission period. I'm not going to go into detail on that here, Candace. It's a little different lesson. And then box 3 says, we're exempt from giving this particular form. The most common time that you would be exempt from this form would be new homes. That would be an example of when there would be an exemption to this particular form. But again, if it's a resale, I'm telling you, 99% of the time I want that first box checked.
Yeah, I think that, is a pretty good shortened version of it. I will, just so people taking the test and pre or post licensing will point out that it's a 3-day, opportunity to back out, and they get a refund of their due diligence fee, which if they back out within the 3 days, whichever the following events occurs first. So once you hit one of these points, you can no longer back out. So very quickly, the end of the 3rd calendar day following receipt of the disclosure statement, you have the end of the 3rd calendar day following the effective date, or the settlement or occupancy by buyer in case of a sale or exchange. So again, we're not going to go into too much detail right now, but whether you're taking a test or you're in real life, just make sure you understand that.
Importantly, get this form to the buyer before they make the offer, and it wipes out that second bullet point, and you don't have to worry about getting into discussions about that at a later time.
And our next section is what I call the MOG, because it is the Mineral, Oil, and Gas Rights Mandatory Disclosure. So Chris, go ahead and tell us about that.
It's almost ditto to what we said about the RPOD. The buyer should receive this. It's actually part of the same act that the RPOD was created. And that's why it follows the same rule. Get them the MOG before they make the offer. And it's just simply going to ask questions hey, seller, have you removed the oil, gas, or mineral rights from your property? Has anybody else done it? Do you plan to do it? Those are the questions. I will say this. I don't want to confuse you by what I said about the RPOD. Please understand that the MOG, while it falls under the same law, the exemptions for the MOG do not include new homes. There's a long story behind that, but that's the short answer. New homes would not be exempt from the MOG. You know what's interesting? The most common question I get about the MOG is whether it's necessary if you're selling a blank piece of land.
And what do you tell them?
The answer is no. It's only designed for properties that have residents on it.
Yep.
And that's because it falls under the same act as the Residential Property Owner Association Disclosure Statement.
Exactly. All right. So our next section is buyer obligations. So if the last section was, hey, here's what you need to know, I'm representing things to you, seller, this section is telling the buyer, what am I going to be doing? Right? Now, I think this first one is really important, not only for the test, but for real life, right? It's responsibility for special assessments. And the buyer shall take title subject to all special assessments that may be approved following settlement, right? So, yeah. It's your problem if it happens after settlement, buyer.
Couple of things for test purposes. You should treat a proposed special assessment throughout this contract. They'll hint at proposed versus confirmed. Proposed means that it's on the books. It's probably going to happen. Treat it like a material fact. The seller should tell the buyer that. If the buyer doesn't want that, they shouldn't buy the house, because notice that this clearly says that they're going to be responsible for any assessments approved after closing.
Yep.
Later, this will also be addressed on the seller side as well.
Yeah. Yes, I agree. And we're going to move on to responsibility for certain costs. This is where you get the information or who's paying for what the buyer needs to pay for on the CD or the closing disclosure, right?
Yeah, one of the things that outside of this form and outside of the test in the field, be very, very careful right here. We do an amazing job doing a net to seller, talking how much they're going to walk away from the closing with. But I think agents do a poor job explaining to buyer how much they're going to have to come to closing with. They may think it's a 3% loan. They're only coming with 3%. Notice all the things that they list here
There's a lot
that
of
the
things.
buyer is likely going to be responsible for.
Right. And then, this is just some legalese saying the buyer's going to let the lender and the attorney and the agents all talk so we can get together.
Yes, I'm not even sure if the attorneys understand that.
He said it, not me, attorneys. He said it, not me. All right, seller representations. So the first thing the seller is going to do is let us know whether or not they've owned it for a year, or if they've owned it less than a year, or whether or not they don't yet own the property. Pretty simple one.
Yeah. There's long stories behind that, none of which are necessary. It's a asked and answered question.
Right. Now we know our next section deals with lead-based paint, and if a house was built before
1978, and just in case you forget, it's actually in that paragraph right there, and that is hugely important. Again, in the haste and pace of things, sometimes you forget some of these ancillary forms, but the house was built before 78. Absolutely, please get that.
And the seller is going to give us representation or information about any type of owner's association. And when I scroll, we're going to get information about the names. And, sometimes you have more than one association. How much are you paying? How often? Where's their name, address? All of this information that a buyer would want to know so they can check out information about the HOA.
Yes, and of course in the RPOD, some of this is addressed so the buyer could be able to lift from the RPOD and put it into this particular form. Not specifically important for test purposes, but very important in the field.
Yep. And we have the fuel tank section. Now, I don't want to go into too much detail for pre or post, but if you had to sum it up in a couple sentences here, Chris, for real world.
Okay, the one of the great things that happened this year is they put all the fuel tank information together on the offer to purchase and contract. In the past, it was spread out in 3 places on the contract. It now matches the language in the listing agreement. So if the sellers and the listing agent should be able to provide this information, and basically it's asking a couple of questions. Do you have a fuel tank for heating your property? Is it buried? Do you own it or do you rent it? And as if you go down through that little list there, you will see it seeks to answer those questions.
Yep, because we got to ask if it's in use. We need to know the location, and we need to know what's in it, and we need to know who you got the fuel from.
Yep,
right?
yep.
And I like it. And then what about if there's fuel in the tank, Chris?
Okay, this is a long story that really doesn't need to be for this purpose, but while you're in the field, here's the way we're treating it as of this iteration of the contract. If there is fuel in the tank at the time of closing, it's treated like a fixture. And to give you, you may hear that and you may say that sounds obvious. Well, in the previous generation of this contract, the seller could go and remove the fuel oil and be compensated for that by the company. They can't do that any longer except for the fuel that they need to heat the property. So here's the short version of what it says now. What it says now is if there's any fuel in that tank, it's going to become a fixture and the buyer will get it with the transfer of the house.
Yep. I mean, the seller can use it, but that's going to be the buyer's fuel now.
Right.
All right. And next section, we have seller obligations. And I think this title on section A is pretty clear. The seller needs to give evidence of title and how much they need to pay off on any loans, or if they're, have a non-foreign status, just legalese.
Legalese on that. I do want to go back to the word seller obligations, and I'll let you speak to the paragraphs there for just a moment. But notice things just got really, really serious here. It is rare that the seller is in breach. However, if the seller doesn't fulfill an obligation, they could be held in breach. So this provision is going to wrap up by saying that very thing. What I'm pointing out to you is there's a difference between a representation and an obligation. We're now into obligations.
And these are things the seller must do.
Yep.
So they have to give evidence of title. They are giving authorization for the seller to the seller's attorney, their lenders, whoever it may be, so we can move forward with the information on a closing disclosure. The seller is required to give you reasonable access to the property before closing, right? Or if the buyer moves in early. And that should be a conversation. There are lots of things that happen around this, but the seller does have to be somewhat reasonable. What does reasonable mean? I don't know. But I think communication really helps this one, yes?
Yeah, a couple of things. Simply put, reasonable would clearly include allowing the buyer to come in and do their investigations of the property. I think buyers have to be reasonable too. Don't just come in and show the house to your friends, your family, your college roommate, et cetera, et cetera. Try to get this done in a few visits. But I will tell you, buyers and sellers sometimes start to hate each other during the settlement period. And sometimes the sellers will do foolish things like cut off their utilities.
And they cannot do that.
Yes, paragraph specifically penalizes them for doing that. More than once I've had to have sellers come back and turn on utilities so the buyer can do his final walkthrough.
The seller needs to remove their garbage before the person moves in, or, basically by closing or settlement, whichever you want to call it.
We call that, how about the in adults paragraph?
That is very true. And I'm going to go ahead and skip down to some stuff that's important, like this good title and legal access. And I'll read this because at this point in your class, this should make sense. Sellers shall execute and deliver a general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple and marketable and insurable title without exception for mechanics liens and free of any other liens, encumbrances, or defects, including those which would be revealed by a current and accurate survey of the property. Okay, that's a lot. I'm going to stop right there because that should make sense, right?
Yeah, it does make sense. A lot of this is above our heads, though, and meaning that if something comes up, don't try to argue with the other agent about what marketable title is. You're going to have to talk to attorneys and find out if something came up that would affect the marketability of the title. General warranty deed, again, we know what it is, but we're not going to get into fights over things like this. Lawyer up if it goes to that point.
And just remind your buyer that they are going to have some encumbrances on the property. They have to, the taxes are going to come with it, and that will be prorated or basically split between the buyer and the seller. There could be utility easements. Of course, you'll have your covenants and restrictions. Other things like that. They can't get rid of an electrical easement. That's not the seller being in breach.
Yeah, and I do actually like that for a test question, is to understand that properties never convey with no encumbrances. It's almost impossible to not have some encumbrances. But notice if you look at that paragraph, it says they do not materially affect the value of the property. They're actually for the benefit of the property, like the restrictive covenants and utility easements.
Yeah. And we got 2 notes. The first saying, hey, buyer, you probably should get a survey, but even if you don't get a survey or you don't hire an attorney to look at the title, it doesn't mean the seller doesn't have to provide good title. And then if this is going to be a short sale, you're going to need some additional paperwork.
We have a form for that.
There's a form for almost everything. Okay. Now, when it comes to our next section, the seller is going to pay for the preparation of the deed and any other documents needed because they've got to give title, right? And they're going to pay for any excise taxes. Right? Oh, and I should probably point out any deferred, discounted, or rollback taxes and any local conveyance fees because different parts of the state, different things. And then we have who the deed's going to be made out to. Now, you should fill this in, buyer's agent, to the best of your ability, but also make sure that attorney has a discussion with the buyer.
Yeah. And just real quickly, another test comment on this. Since we're not doing a full length settlement statement any longer, it's still important to know what the standard things are that the seller pays, even if just for a net to seller. The seller, for our class, always pays commission. They pay for preparation of the deed so that it can be conveyed. And they also pay for the revenue stamps, excise tax is what they're contemporarily
And if
known.
there's any quitclaim deeds to remove any liens.
That's correct. And notice that Kandyce also made the point in there that if there's any old taxes, the seller pays those. Those aren't prorated. That'd be silly to make the buyer responsible for part of that.
Exactly. All right, we're moving along. If the seller wants to pay any of the buyer's closing costs, that would be filled out there. Let's see. And let's just jump to K because I think K is really important here. Payment of special assessments. Seller shall pay in full at settlement all special assessments that are approved prior to settlement, whether payable in a lump sum or future installments, provided that the amount thereof can be reasonably determined or estimated.
Yeah, again, I would have you look at 2 things here. Remember earlier we talked about a proposed assessment, which basically is an assessment that is going to happen but has not happened yet. Tell the buyer about it, and if they buy the house, they're responsible for it if it happens after closing. But notice here it's fairly clear that if there's an assessment that occurs prior to closing, and I don't care if it's 1 day, I don't care if they broke it up over 5 years, if it's approved prior to closing, it's the seller's responsibility
To pay it in full.
Yep. If that ends up being a $13,000 assessment, your seller needs to know that so that they will know to deduct that from their net.
All right, I'm going to point out one of my favorite lines, negotiated repairs and improvements. Negotiated repairs and improvements shall be made in good and workmanlike manner, and the buyer has the right to verify that. First, y'all know what you're supposed to do. Do the work the way it's supposed to be done. Hire professionals. And buyers, please just double check.
Oh, wow. And agents as well. This is one of the most commonly written up things on the back of the bulletin is agents and buyers who have ordered repairs and the seller agreed to do them and they never checked to see if they were done.
An agent, if it's something that you can reasonably discover, that's on you. All right, our next section is home warranty because sometimes a seller will give a home warranty. Sometimes they won't. Sometimes they've already gotten it. Sometimes the buyer gets to choose what it's going to be. Then that's fine. Right? And let's see, we've got our charges by owners association, which I think that's pretty clear. Yeah, and this breaks down what the seller shall pay and what the buyer shall pay.
They actually did a good job on the contract. These used to be separate in the contract. They've moved them together so you could be a little more specific about this. And basically, if it's something that's needed for the seller to fill out the RPOD or something like that, the seller is responsible for paying the cost of finding that. And then the buyer is responsible for things that are going to affect their future use. In other words, if he wants to put up a fence, well, that has nothing to do with the seller. He should pay the fee to the architectural committee to do that. As Kandyce said, it actually is very well written, so just study that.
All right, our next section is prorations and adjustments. So this is just talking about the fact that we're going to split the taxes on real property. We'll prorate rents and dues, and of course taxes on personal property. I mean, if it's being conveyed. But what's most important, I love this section, is the condition of property and risk of loss. So Chris, talk about that a bit.
Do you want the simple version or the difficult version?
Simple version.
All right, here's the simple version of this. The condition of the property should be the same as it was at the time that you went under contract, same or better. Notice that what she's highlighting there. So in other words, if the buyer goes under contract on the property and everything's looking good, and then something breaks during the escrow period, well, technically the seller owes it to the buyer to bring it up to the condition it was at the time of closing. Having said that, the risk of loss refers to this. The seller is responsible for the risk of loss up until very specifically the time of closing. Doesn't matter when possession changed hands, it matters when it closed. So in other words, the seller needs to keep their insurance up through the time of closing, and at closing, the buyer picks up his insurance. This is actually a very logical paragraph.
I like it. All right, section 12, delay in settlement in closing. So I'm going to kind of sum this up. We know that we chose a date earlier. What was that, page 2 maybe, page 3, where we said, hey, this is when we want to have our settlement in closing. That date is not time being of the essence. And sometimes things happen, delays happen. And so what we're going to say here is that you can be entitled to a delay in settlement, and you got to tell the other side that you need to settle. But you're never going to have more than 7 days from the last date that you all agreed upon that you were going to settle/close. So basically, if I choose a date and I need a couple more days because maybe something with my loan, or maybe I'm a seller and I need a couple more days, to get out of the house, fine. You need to let people know. But if you wait more than 7 days, then the party who is delaying, the person that's got the problem, then it's kind of bad news, because the person that's not holding up the settlement can terminate this contract. And then if you're a buyer, you would get your earnest money, due diligence money back, and possibly any other fees that you would want to, have covered, right?
Yeah, literally after that 7-day grace period, if you are the delaying party, you're going to be in breach. And Candyce just told you what the remedy of that could be. The other party could terminate, and they get whatever the spoils of the contract are on that. Interesting point on this. First of all, the 7 days is likely a testable thing. In the past, it's not uncommon that they have tested on the number of days for the grace period. Having said that, if for some reason you know that you're going to be late, buyer's agent could always ask for more days if the buyer is the delaying party. And if they ask for an extension and the settlement date is extended, by definition, the grace period would be extended as well. Very important in the field, maybe modestly important for tests. I don't know.
I still think it's important.
Okay.
All right. Our next section is 13, possession. Generally, at closing, the buyer will get possession. However, sometimes, not one of my suggestions, a buyer will move in before closing, or a seller will possess, after closing, and or there could be tenants, right? But if any of those things are happening, you need to call an attorney. Yes, there are some forms for that, but you really want to talk to an attorney, and you want to make sure that buyer/seller talks to their insurance people to make sure they're covered.
Yeah, much more complicated in the field, but for test purposes, this is very, very simple. Possession should change at the time of closing, and we have forms if otherwise. But as Candyce said, it's way more complicated than people give it credit for. Talk to an attorney quick.
I think we're coming to the end here, so let's talk about addenda. We're not going to go over them right now, but if I were to say the ones that, most definitely you should be familiar with, the additional provisions addendum, which is where you can add a, what do you call it, when the expiration of offer, right? We have a backup contract addendum, the FHA financing, VA financing addendum, of course, the lead-based paint hazard addendum, and I think that's pretty much the big ones, yeah?
Yeah, I would say additional provisions and FHA, VA, those are the ones that I see probably 50% of the time.
I love it. All right, we know that this contract cannot be assigned without written consent of all parties unless it's a tax-deferred exchange, right? And if it is a tax-deferred exchange, the seller, whoever's doing the tax-deferred exchange, needs to cover any costs that come with that. If the buyer or seller needs to sign, the person not doing the exchange needs to sign something, they will, but those extra costs should be on the person doing the exchange.
Yeah, in regards to the assignment, the test question on the assignment is all contracts are assignable unless they say otherwise. And notice how this one specifically, it says otherwise unless there's written consent of the parties. I would ask you to also compare that with the word novation if you're studying at home.
Exactly. Our parties. This is going to be the buyer and the seller. And I like to point out their respective heirs, successors, and assigns. That means death does not terminate this contract. Death by the buyer or seller does not terminate this contract. If there are heirs that need to get involved, then those heirs need to follow what it says here in this contract.
Yeah, some other stuff could come up. This happens actually more than you think it does. I'll throw one other thing that's not specifically related into it, but it could be testable as well. As Candace said, the parties are buyer, seller, their heirs, and successors. If the seller dies, then their heirs are obligated to complete the contract. According to the contract, there may be some other stuff that comes up civilly that's outside of the test. One of the ones that came up this week that was kind of interesting, Candace says we had a party that was under contract, and there was a seller who died, and the other seller had a power of attorney. What happens to a power of attorney when the party dies that you had the power of attorney for?
That sounds like a call your attorney question.
It's definitely a call your attorney, but it ceases to exist. Power of attorneys are no good. You can't have a power of attorney
for a dead person. Oh, that's sad. Okay, but moving on. We have survival. Now, a lot of people tend to think that's like, oh, if somebody dies and who survives, but that's not it. This is saying if you make a promise or you agree to something, you still need to do it even after closing. So if you promise to repair something or put in new carpet, you still need to do that. 19 says this is the entire agreement. And we've already told you, if it's not in writing and part of this agreement, it doesn't count.
Perfect.
Right? And then going to the end, the conduct of this transaction, we're just letting people know it's okay if this happens electronically. Right? And we'll notice the last couple pages has a notice information section, which is just saying, here's how you can contact me. Here's how you can communicate with me.
Yeah, this paragraph is also the one that says communication to a party or to such party's agent is considered communicated. So think about how that affects the effective date of the contract. Offer, acceptance, communication back to the party or to such party's agent.
Mm-hmm. Execution, just, we got to sign it. And there could be more than one copy. That's fine. And Chris mentioned this earlier, computation of days and time of day. Unless it says that banking day for the earnest money or due diligence money that wasn't received, we're talking about calendar days, consecutive calendar days, which include Saturdays, Sundays, and holidays, whether federal, state, local, or religious. Calendar days.
Take that into consideration when you're setting your due diligence date, your settlement date, etc.
Mm-hmm. Now, we've got another, or I think our last really big section here is our remedies, right? So what happens if the buyer breaches? Well, if the buyer breaches, and let me just say, it says material breach. You need to call an attorney to decide what a material breach is and what a material breach is not. But once that is decided that there has been a material breach, the seller shall be entitled to any earnest money deposit, right? And any due diligence fee to the seller.
Yeah, and notice in the next line down, it mentions the word liquidated damages. I mentioned that before. If the buyer breaches, he already knows up front what it's going to cost him. It's going to cost him his due diligence fee. Technically, that's not considered a penalty because he got what he paid for, the right to due diligence. The liquidated damages is the earnest money, basically saying, here, seller, I screwed up, keep my earnest money.
Right. And it's always, always, always important to point out to the seller that this is their only remedy. They cannot sue the buyer for specific performance. So I know people have talked about due diligence amounts being high in the past, but hey, seller, you need to make sure that this due diligence and earnest money amount is going to keep you happy if the buyer does back out for no reason, because that's all you get.
Yep, great point.
Now, Chris, what happens if the seller breaches?
Okay. Now, a lot of people think, well, how in the world could the seller breach? But if the seller cannot deliver title, or if they refuse to deliver title, let's look at both of those things, and let's throw in a couple of vocabulary words to go with it. If the seller can't deliver title, for example, they have a title defect and they're not able to deliver clear title, and the deal falls apart, the buyer will actually be entitled to compensatory damages. And here's what I mean by that. The buyer would get his monies back that he's already put in. But to be quite honest with you, that's small consolation, because that was already his money, the due diligence fee and the earnest money. So it makes sense he got those back. But the seller, according to this contract, would have to pay him for any reasonable expenses he paid in an effort to acquire the property. So that's what we mean by for compensatory damages, to compensate the buyer, to make him whole if the seller breaches. There is one other word to be familiar with, and they've actually added this into the contract now, that one remedy that the buyer has if the seller changes his mind and does not want to deliver, the buyer has the right to sue the seller for specific performance, and that's one of your vocabulary words.
Mm-hmm. All right, and then attorney fees. How about this? If you sue somebody to get your money and it should have gone to you, then they need to pay the attorney fees.
Yeah, and by the way, this paragraph makes it sound so much easier than what it is. Clearly, if you have two parties that are in a dispute about this, let's let the attorneys handle it at that point. We cannot give legal advice on this.
Exactly, because that's why we have this note. You need to CYA. Call your attorneys. Once somebody starts mentioning the word attorneys and they're unhappy, I'm not stepping out, but I am stepping back. All right. This section just says, hey, the Association of Realtors and the Bar Association say this form is good, but if you have questions, you should consult a North Carolina real estate attorney. A real estate attorney. All right. And then it specifies again that this offer shall become binding contract on the effective date, right? And it spells out the buyer's failure to timely deliver any fee, deposit, or other payment provided herein shall not prevent this offer from becoming a binding contract, provided that any such failure shall give seller certain rights, which we saw earlier,
correct,
right, to terminate the contract as described herein. Basically give that written notice, and the buyer has one banking day.
Correct.
Whew. Well, I think we can basically wrap this up and say everybody's going to sign. And of course, you want to be careful about wire fraud, because there has been a lot of that the past 5 or so years.
Yeah, that's we talk to our clients about this in the agency agreements. We talk to them in the offer to purchase. And a lot of firms, including the firm I work with, we actually provide a form specifically to help them understand wire fraud.
Exactly. And then we have this page on notice information. This is the page where you're telling the other side, here's how you should contact me. And you're telling, for the agents, you're saying, hey, am I the listing agent or the selling agent? Of course, I just said that backwards. So you got the listing agent over to the right, the selling agent on the left, and then that's going to be the firm, and here's the actual agent's names, and notice you have their license numbers.
Yeah, interestingly enough, a lot of agents get kind of cavalier on here. It's at the end, and it really doesn't involve the buyer and seller that much, but actually remember the effective date of the contract, offer, acceptance, and communication. You have to communicate to a party the way that they have asked to be communicated with.
Mm-hmm. All right, and then we have acknowledgement of receipts of monies. I mean, it's money, y'all. So if you're getting money, make sure that you acknowledge it. So when the listing agent gets due diligence, it should be noted. When the seller gets the due diligence from, wherever they're getting it from, it should be noted. And when the escrow agent gets the initial earnest money deposit or any additional earnest money, it should be noted as well. And Chris, that is page 16 of 16.
Yes, in an effort to make this shorter this year, it went from 15 pages to 16 pages. So
yes.
How do you like that?
I know this took us a while, but we had some really good information in here, whether you're pre or a post, or even if you're practicing.
Yeah, back in the day when I started out, we had a 2-page contract, so it was very easy at the time. But having said that, any opportunity you have to go over your contracts, know them. This will separate you from other agents. If you look professional, people will respect that. And if you have questions, ask a BIC. And then if the BIC has questions, they should ask an attorney.
When you started real estate, was that when the dinosaurs roamed the earth?
We had to etch it actually in stone. That's why it was only 2 pages.
All right. All right, well, we're going to say goodbye. We really hope this was helpful, and you should definitely check out our videos on the exclusive right to sell listing agreement and the exclusive buyer agency agreement. Right. All right, y'all have a good day, and I guess you'll hear from us soon. Bye, everybody.